Hello, class. This is a video dealing with Chapter 16 and 17. As I mentioned, I was going to try to post a few of these throughout the term just to highlight some particularly important chapters. And I think Chapter 16 is one of those. Chapter 16 deals with tort reform, which is a significant argument in the legal system. What should happen? And the crux of it is this. Is the tort system meant to compensate, or is the tort system also, or perhaps independently, meant to be a deterrent and to punish? What we've seen over the last 30 and 40 years as the system has grown and grown is we've seen expenses rise, medical expenses, insurance expenses, litigation expenses. And the idea is that maybe the tort system has been perverted in some way and taken from its true purpose, which is simply to put somebody back in the position that they should have been in and compensate them for their losses. The book uses the phrase karmic adjuster. That's part of that progressive idea of torts. But look at tort reform this way. Tort reform, one of these suggestions, for instance, is caps on damages. And the idea of a cap on damage is that people will be less likely to sue if they're less likely to hit that jackpot. If you get into a car accident, compensatory injuries will never be capped, meaning you're out of pockets. Whereas punitive damages, the damages that punish, are capped. Sometimes at $100,000, $200,000, just depends on the state and depends on the type of case. The caps on these, part of it is to create stability in the system. If you're an insurer or if you're a doctor or medical provider, you want to know my worst case exposure is, let's say, $200,000 versus I could get hit with a $20 million verdict at some point. That stability is good for costs. And also the less money that's being pulled out of those areas, insurance, medical providers, the idea is the lower your premiums will be and costs will be. The downside of the tort reform argument is this. Firms that handle personal injury cases take a certain number of low probability wins because they have facts. So somebody could have a legitimate injury, could legitimately need to be compensated, but have a poor legal argument under the law for whatever reason. Those people have their cases litigated because firms know if they take 10 of them, for example, all they need is one to hit big in order to make up their costs for all the rest. When you take that possible big victory and you cut it down to $200,000, firms are less willing to take those types of cases. I oftentimes share an example of a case where I had a former client contact me. The woman was 76 years old. She ended up getting injured in a medical facility, having a head trauma, recovered. And then during her recovery, she was injured again due to a nurse's neglect. She was, as I said, 76. She was working part-time. She was living with her daughter and caring for her husband, who had Alzheimer's, and also her grandchild, who had cerebral palsy. When she died, she could not find an attorney to take her case. The family could not find an attorney to take that case because the value of that elderly woman working only part-time was so small they were worried they could not recover enough based on caps on damages. So the compensatory side was limited, but the punitive side, had it been unlimited, a firm may have actually taken that case. So that's kind of the flip side of the tort reform process. Those cases where there may not be a lot in compensatory damages, but that somebody deserves to be compensated, is the flip side of the tort reform process. It's not an easy question, and I'm not suggesting that there's one right or one wrong. There are downsides of not having caps. The book talks about defensive medicine, which is a big part of it. Doctors being careful so they don't get sued versus taking aggressive tactics or using some creativity and some ingenuity to try to resolve issues. Instead, they're very defensive about things. That's not necessarily a great way to get treated. When you're reading, make sure you take a good look at the punitive damages section, especially the part where it talks about punitive damages can violate due process. So I always tell people when you're thinking of punitive damages, you don't need tort reform, you don't need caps, because a jury gets to limit damages first and foremost. A trial judge can reduce a verdict second. And then third, it can go to an appellate court. An appellate court can reduce a verdict if it's disproportionate, if it violates due process. So ideally, you would want one of those three mechanisms to create its own self-established tort reform process, or cap, if you will. All right, on the auto insurance side, not the most interesting area of the law, I will tell you, but when you're going through that chapter, what you need to focus on are the different types of policies and the different types of coverage. Make sure that you know about liability coverage and medical malpractice coverage and comprehensive, collision. Know those definitions and terms. Those are going to be important to you. And then know the different types of policies, umbrella policies, reformation policies. 17 is very much heavy definitions, heavy terminology. So pay close attention to that. And then on the legal side of things, as far as other legal terminology, know what the concept of subrogation is. Subrogation, where the suit in the name of the insured is actually collected by the insurer, so the insurer sues on the party's behalf. And then getting down a little more nuance, primary coverage versus secondary coverage. If the insured is injured in a motor vehicle owned by someone else, that's the primary coverage. Or on the secondary coverage, if the insured's medical expenses exceed those owner's limits. So the secondary coverage comes in if there's anything left over. So know those subtleties, but on a big level, on a higher level, make sure you're familiar with the terminology and the definitions of the different types of coverage and the different types of policies. So, I hope this has been helpful. Please take a look at tort reform, and if you have any interest, do some little research on your own and form an opinion on whether you think there should be caps, or whether it should be left up to a jury, judge, and ultimately an appellate court, whether those verdicts are constitutional and appropriate. Have a good week.